Do you understand that it is your decision and your decision alone as to whether or not you testify in this case?
Yes.
I strongly suggest, though, that you base that decision on consultation with your attorneys. So I want to ask you if you've had sufficient time to discuss your decision with your attorneys.
I have.
Have you made a decision?
Yes, I have.
What is that decision?
I'm not going to testify.
All right, Michael Keetley did not testify at his trial. His defense attorney did not give a closing argument, yet still the jury did not convict him. As a matter of fact, they came much closer to finding him not guilty. It was a hung jury. Amazing. And now we're getting ready for the retrial of the so-called ice cream man. Chanley Painter has more.
The jury has reached a point in the deliberations where, after much and thorough discussion and many votes, it is certain that we cannot reach a unanimous verdict.
On day 2 of deliberations in Michael Keetley's murder trial, the jury declared they were hopelessly deadlocked.
At this time, ladies and gentlemen, I am declaring a mistrial in the case.
It was 10-2 in favor of acquittal of a not guilty. 10 jurors were voting for not guilty.
Now, Florida prosecutors say they will retry the former ice cream truck driver on murder and attempted murder charges for a 2010 shooting that left 2 brothers dead and 4 people injured.
What did you do when you saw that photograph?
I started to cry.
Gonzalo Guevara was the sole survivor to identify Keetley as the gunman in a photo lineup.
What did you tell Detective Lugo about that photograph?
That that's the guy that shot me.
Throughout the trial, Keetley's defense tried to cast doubt on Guevara's identification.
I truly believe that Gonzalo Guevara thinks that he picked out the right guy. If in fact he did identify the photograph of Michael Keetley as opposed to another photograph. But I believe he believes it, but I don't believe it.
Hillsborough County prosecutor said Keetley was out for revenge after an armed robbery on his ice cream truck crippled his hand.
He became frustrated. That frustration led him to start his own investigation. His investigation, I suggest to you, which occurred over several months, became an obsession.
Brothers Sergio and Juan Huitron were killed, but Keetley allegedly targeted the wrong people in the early morning hours of Thanksgiving 2010. 4 of their friends survived and relived the harrowing ordeal on the stand.
He ordered us to get our IDs out and get in the ground, and he cussed us out, and he had a rifle with him, and he pumped it, he clocked it.
The state called a firearms analyst who said casings and projectiles from the crime scene and Keetley's property were fired from the same gun. The defense called Keetley's surgeon to cast doubt on his ability to fire a gun.
On a scale of physically possible to physically impossible, what is the likelihood that his right hand, fingers, and thumb could independently open without the use of his left hand on November 25?
Impossible.
The public defender's office will represent Keetley at his retrial after his lawyer of 9 years withdrew from the case.
I feel that it went to attorneys that can also do an excellent job for him.
But with trials indefinitely postponed because of the coronavirus pandemic, it's not clear when Keetley will face another jury. Whenever it happens, the state believes it has enough evidence to keep Keetley locked up for the rest of his life.
And prosecutors obviously had a few issues because of identification and other things in this case. But, I mean, there was evidence that this guy was out to get someone, yet the jury 10-2 was going to send him home. Unbelievable. Chanley Painter is back with us. She was in the courtroom for this trial. Chanley, really an amazing case. And I think part of the amazing, what transpired was that we really didn't get closing arguments in this one.
It was a shock, Vinny. I remember watching this trial live, and the prosecutor, he got up there and he spent maybe 10 minutes on his first close, expecting that he would have a rebuttal closing argument. He even told the jury that he would explain in further detail the evidence against Michael Keetley. And then he sat down, Vinny. We had this sort of pause, and then out of nowhere, the defense waived closing argument, really undercutting the prosecution. And we all sat there wondering, is this going to affect Michael Keetley? What will the outcome be? And then when the jury couldn't reach a decision and it was a mistrial, we're left wondering if the waiving of the defense close had anything to do with that.
Absolutely. But I know that we spoke with Leanne Gowdy, and she gave us a taste of what that closing argument would have been if she presented it. Let's take a listen.
The theme was the same, which is that the state's case is based on unreliable identifications and circumstantial evidence that does not prove beyond a reasonable doubt that Michael Keetley was the shooter in this case. And so that was the theme I picked the jury on, I opened with, and I cross-examined on, and I was going to close with. And I was going to use some of the state's evidence to establish that, because some of their own evidence actually, in my opinion, conflicts with each other and actually shows that, you know, the circumstantial evidence that they want to say points to Michael Keetley's guilt is actually inconsistent with his guilt. And so that's kind of where we were going with, where I was going to go with the closing.
You know, sometimes people say, you know, the lawyers don't make a difference. It's all about the facts. No, lawyers do make a difference. And I think that was very evident in this case.
Absolutely. And what an attorney Leanne Gowdy was. She was a pleasure to watch during that trial throughout. And I hated to miss out on her closing argument because it probably would have been fantastic, like she described, reinforcing those themes of her case. And interesting that she does tell us it was 10-2 for not guilty. And I know we're going to play her extended interview later in the show, but she talks about those other two who they weren't fully on the guilty side. They had just some lingering questions. And so maybe if she would have given the defense closing, maybe that would have brought the other two over for an acquittal. We just don't know.
Yeah, it was 10-2, but if I was on the jury, it would have been 10-3, Chanley, because to me, that the one piece of evidence that I just found so compelling, and you know, I don't do this most of the time, but not all the time. The piece of evidence I found so compelling was the night of the shooting. Didn't he have like an all-night painting session of his van?
That was one of the prosecution's most damaging pieces of evidence, is that he immediately takes his minivan to get painted, and the bottom is two-toned the next day. And also, Vinny, a strong piece of evidence for the prosecution were that those shell casings that were found at the crime scene matched those at Keetley's property. In fact, the expert testified that they were shot from the same semi-automatic handgun. So yes, overall, the prosecution, and in their own words, has a very strong circumstantial case.
Yeah, we'll see. You can turn it around. We've seen it before here. Let's take a listen to more of Leanne Gowdy here, talking about why she's withdrawing from the case after 9 years.
Michael Keetley has known all along why I was initially brought into the case and the amount of work that I've done on the case. And he and I discussed over the years that I would stay with him through one trial, which is what I tell every one of my clients that hires me. I'll do one trial on your case. And I did that trial. And unfortunately, we came close to getting that acquittal because I got a jury call who told me that it was 10-2 for not guilty. But we didn't quite get there. And so for all the reasons that I'm sure everybody can understand, when you're a small firm in a case this large and complicated, from a financial perspective, we took a bath on this case. But we felt it was the right thing to do, and I felt very committed to him. But we can't do the retrial. And so for those reasons, I withdrew. He completely understood with the withdrawal. And we have the public defender's office, thank God, was court appointed by the court which has a homicide division and has the resources to staff the case with multiple lawyers and multiple support staff.
All right, Chanley. So what's next here?
Well, the retrial was set for May. That has been postponed indefinitely due to the coronavirus. In fact, they have a status conference in June. Now, the prosecutor's office says they are set on retrying Keetley, but they are open to discussions for a potential plea that would take into account what they think he's guilty of. So we will just have to wait and see.